understanding on what those actually entail, what the difference is. I'm attorney Justin Randall with Hooper Law Office, and just a couple quick things to go through before I dive too much into detail here. This is an interactive webinar, so if you have any questions that are coming up as I'm going through things, if you submit the question to the Q&A function on Zoom, I'll be able to actually see those come in and be able to answer them as we go through things. You'll also be receiving some things at the end of after this webinar is over through email. So we have a couple materials that we're handing out, sort of our chart on what goes through probate, what doesn't go through probate, as a kind of handy tool to look at, maybe assessing your own situation. And then you'll also be receiving a feedback form where you can let us know if, based off of any concerns that you have that come up from this webinar, if you would like to come in and schedule an initial consultation. Those are complimentary, and we do schedule them for about 2 hours to give us enough time to go through the situation. But again, it's complimentary, so it doesn't cost you anything to come in and talk to us and ask your questions and see what we can do to help you or your family based off of your situation. So we do these every week, and our topic next week is actually going to be on so March 8th. Same time as today will be on gifting, in relation to what gift taxes, sort of how those are tied into gifting, and gifting in terms of the potential long-term care consequences as well. So that'll be a really interesting topic, I think, for a lot of people. Okay, so to get started, we're talking about the fundamentals of probate and trust settlement. So I wanted to start with sort of what is probate and what is settlement or trust settlement. What does that actually mean? A lot of people, when I start talking about probate, I sometimes forget that not everyone is an estate planning attorney, right? And doesn't understand maybe doesn't know what probate actually is. And so I'll get the question of what is probate? Well, probate is the process in which, the court helps follow the terms in your will and divide up the assets subject to probate in accordance with those terms, and make sure that creditors are paid, that people are appointed and able to act on behalf of the estate. So it's really, after you pass away, if you have assets going through probate, that is the process in which your will is followed and assets are divided up in accordance with that will, I should say. And if there's any sort of like special terms in the will of how someone inherits, whether it's in a trust fund or you're restricting it in any way, that's where you set that up. So with that discussion, a lot of people don't understand that if you have a will, you're not just automatically avoiding probate by having a will. I think the biggest misconception is that if I have a will, I'm not going through probate. Probate is only for people who don't have any wills at all or no plan at all. Where wills really come in is they are specifically, from a legal perspective, they're an instruction to the probate court of what you want to happen, who you want as guardians for your children, who do you want in charge of the estate, those sorts of things. So you couldn't take a will down to the bank after someone passed away and just say, see, this is what the will says. The bank doesn't care what the will says until probate has been started by filing that will. So don't think you're avoiding probate just by having a will. There's nothing wrong with going through probate, though. I think a lot of people have misconceptions or have had bad experiences with it, right? So there's reasons to avoid probate, but there's absolutely reasons to go through probate as well. The three biggest reasons to go through probate would be, I've mentioned one already, is if you have minor children. Because you have to name guardians in your will specifically for the kids, that means there's going to be some level of probate if you have minor children that need guardians if you pass away while they're still minors, right? So if you have minor children is probably the biggest reason most people would have to use some level of probate. A second reason is if, for example, somebody has a deficit estate. So a deficit estate, what I mean by that is they owe more than they have, sort of like your estate's filing for bankruptcy. Probate is a perfect place to deal with that issue because the personal representative that you name in the will, they have a duty a legal duty to do certain things, follow the rules on probate, make sure that they're giving proper notice to people, including creditors, right? Making sure that they're, maximizing the value of the estate, which may mean giving notice to creditors, and hopefully they don't come forward and, then their claims are absolved, right? So you can't just not give that notice. So when somebody has that deficit estate, it's really important to go through probate to help the family or the personal representative deal with that issue and make sure that they're not doing anything wrong, and that they're just following the rules the way they should be. The third reason, and maybe one we maybe deal with more than your average person might, is specifically related to certain types of long-term care planning. A lot of times, what we're doing with long-term care planning is in somebody's will, we're putting in provisions that deal with protecting certain assets if one spouse passes away and the other spouse is receiving Medicaid in a nursing home. If that's the surviving spouse, there's things we can do through someone's will to protect certain assets. So that would be another example of, hey, we're intentionally using probate for this. But if those aren't your situations, you don't have minor kids, you definitely don't have a deficit estate, and you're not concerned about long-term care or anything like that, maybe you're not trying to go through probate. Maybe you don't want your estate using that process. So people will do a number of things to try to avoid probate. But you need to set those up the right way in order to make sure that your plan is actually works for you, that there's if you have protections in your documents that you're using, that they actually come into effect. So the biggest problem I think people run into with wills is that because they think they're avoiding probate, or they think they have some sort of control beyond probate, they'll beneficiary designate most of their assets. With beneficiary designations meaning like payable on death or transfer on death, those avoid probate. They pay or transfer directly to the individuals or the entities listed as beneficiaries. So if they avoid probate and pay directly to that individual, though, if in any way it doesn't match what your will said, or even if it does, but you're intending to use the will for some reason, since wills only direct probate assets and they only control assets in probate, if you're not having anything go through probate, your will is effectively worthless to you, which with any plan that you have set up for yourself, you want to use it. It doesn't pay for you to pay someone else to draft these documents only to completely disregard them later, right? You want to actually use what you're putting in place. So if you have a will, you want certain assets to go through probate so that the personal representative has access to them and can follow the will and pay bills, right? So how probate actually works, in reasons people tend to want to avoid it, is probate can take a little bit of time, to say the least, to fully accomplish, right? To fully finish that process. So what you're usually looking at in terms of time frame for someone's probate estate, and this would be an average number, not like a very long one or a short one by any means. It's usually in the neighborhood of a year to a year and a half to fully finish probate, and that's from start to finish. That doesn't mean that it would take that long for someone to actually have access to funds or to start paying bills. That's just from opening the estate as the initial point in time to closing the estate, right? Is usually about a year to a year and a half. So that time frame is a reason a lot of people don't like probate. Is usually people are trying to get things done as efficiently and as quickly as they can, because people don't want to linger on that issue after someone's passed away. They just want to get it done. So that time frame is a big reason people tend to try to avoid probate, is to make things more efficient and easier for someone to deal with, right? Another big reason people tend to try to avoid probate is the cost associated with it. That cost is made up of a couple different things. Usually there is a filing fee based off of the size of the estate that you have to pay to the court. It's not a very large percentage. I think it's 0.2%, for example. So it's not very large. But where the big fees start to come in is if somebody hires an attorney to help them with it, which is a perfectly reasonable thing to do in that situation. But an average cost of probate for an estate is going to be anywhere between 3 and 5% of the estate when all is said and done. So that's kind of adding in all the expenses associated with it. So that doesn't sound like a large percentage until you start to multiply that percentage by larger values in estates, right? So if you're talking $1 million, 3% is $30,000, right? That's not nothing, especially when it comes to a larger estate. So cost is a big reason people tend to avoid it as well. The other side of probate is that it is potentially public record for people to look at what's happening with the estate. Anybody can go, online and look through the court records and request access to those, more specific documents, based off of the fact that the court makes public notice of the fact that, okay, this person's passed away, their estate has been opened, right? That doesn't mean your will is necessarily published online. You still have to request a copy of it for someone's estate, if somebody is trying to get access to it, but it's possible that they could. So if you're a very private person, if that worries you in any way, that may lean you away from probate as a process that you're going to use. Probate is specifically where somebody has their will administered, or if they don't have a plan at all, probate is also a place they may end up. So like I said, though, with probate, you do want to actually use probate for certain assets if the will is your controlling document for your estate plan. Because why would you craft all of the language in there and make sure that there's these terms for beneficiaries and that things are, will go a certain way if you're not going to use it at all? So if you have a will, but then everything's beneficiary designated, that can create a couple pretty big issues for people. And maybe this wouldn't happen depending on the situation, but it can happen, and that is a big risk. When you have a will, the personal representative has to follow the terms of that will, right? It's not up to them whether they change the terms of it or give distributions to people they're not supposed to, or keep it all for themselves, right? They're not allowed to do that. They have a duty to follow the terms of the will. So you actually want assets to be subject to that if that's the document you're using. So what happens sometimes when people have wills, but then have everything avoid probate, is there's a couple big common issues that come into play. So the first would be, for example, the personal representative has to actually use the money to follow the will and to pay expenses and do all of those things. So sometimes what people will do is they'll leave the accounts directly to that person so that they have immediate access to the funds, because with probate, your accounts are not immediately accessible to the personal representative until they're actually appointed and are able to start acting. So it can take a couple of weeks to a month, right, to fully get into that position. So people try to leave accounts directly to the person in charge of the estate so that they don't have to wait that period of time. The issue with that, though, is that a couple of things can go wrong there. One, if that person is named as the beneficiary on that account, that money is theirs now. They're under no obligation to actually follow the terms of the will and divide the assets up, because they're the beneficiary. That's how beneficiary designations work. It's not, you can't put on there that you're leaving it to this person for this purpose, right? You're just leaving it to them. So that can create issues where maybe the personal representative isn't even a beneficiary of the estate otherwise, and therefore that creates an issue there. Maybe they don't decide not to split it in accordance with the will, and they're under no obligation to do so. But the other more common concern I would have actually is that when somebody is the beneficiary of an account, they're on there as the beneficiary, that money becomes theirs, which also means any liabilities they have will attach to that money as well, right? So a personal representative does not own the assets of the estate. They're sort of just in charge of it, making sure they're managing it, right? If they are left that money or that account, what happens if they're going through bankruptcy when that happens, or a divorce potentially, or they're on Medicaid or some other sort of means tested assistance, or they're getting sued for some reason. They may not be able, even if they really wanted to, because of all of those things, they may not be able to actually divide up the account the way the will said to, because in a lot of those situations, people cannot give money away without causing problems for themselves. There's legal reasons for that, especially like in a bankruptcy, right? You're supposed to pay off your creditors first. And if you gift all your money away right before filing bankruptcy, that's a problem. So it may not be that they're not choosing to follow the will, but legally speaking, they can't. That doesn't happen if you leave those accounts to your probate estate, because the personal representative, their own personal liabilities don't matter for the estate. That isn't going to tie up that money in any way. It's not theirs, it's your estate's. So if you're using a will, you actually want to use it, right? You don't want to just draft this will and then have nothing follow the terms of the will. You're opening things up to a lot of potential kind of unforeseen circumstances, creating issues for the estate. The biggest thing too is sometimes, and this is probably more common, sometimes people will divide up their accounts already in accordance with the will. So let's say a will is being divided up 4 ways, or someone's estate's being divided up 4 ways equally. Well, even if all of those accounts are divided that way, what happens when one of those beneficiaries is also the personal representative and maybe uses what they've received to pay expenses for the estate? If you intended for those expenses to be shared equally, but you divide all the money up before those expenses are even paid, you're not guaranteeing that it will be equal in the end, right? There's no obligation for those other beneficiaries to share in expenses. It's kind of out of the kindness of their heart, or legally whether they can or can't, depending on their situation. So what you want with probate is you want the probate estate to pay expenses first before things are divided up, just to make sure that where the final distribution of 25% equally actually is what happens. Because if you don't do that, there's not a guarantee that it will, right? So when we're talking about wanting to avoid probate, but wanting to still deal with all of those issues, that's where we're generally looking more at something called a trust, or a very common kind of trust would be a revocable trust, right? There's also irrevocable trust for various purposes, but if somebody has a trust, trusts are not subject to probate. But what trusts do after someone passes away is they have terms of where the money goes, just like a will would. So they can be written in the same way a will might be, for things like what happens with a minor's money that they're inheriting, or how do you restrict those funds, or are you obligating anybody to pay expenses first, right? Where a will and a trust are very similar, but because trusts are not subject to probate, they provide the same planning a will does without using probate to do those same things. So I tend to, a very sort of simplified explanation of this would be a trust is sort of like a will, or a cross between a will and beneficiary designations in terms of what it does. It provides all the planning that a will does, but it also does avoid probate, assuming assets are properly titled or are left to that trust after you pass away. So a settlement is where trusts are dealt with after someone's passed away. So it's sort of the alternative to probate, right? There's still legal obligations to like make notice to creditors and pay those expenses first before the assets are divided up. So there's still things that people have to do. But the big difference between trust settlement and probate would be a couple of big key differences. So the time involved. For example, trust settlement, usually, assuming everything is going smoothly, it would be more in the neighborhood of taking 6 months to a year, as opposed to that year to a year and a half. So you're on average about 6 months shorter, somewhere in that range. It can take longer. It all depends on how, if there's any disputes that are coming up with beneficiaries, or if beneficiaries start suing the trustee. I mean, any sort of dispute like that is going to make things a little more complicated than they otherwise would be. So the time involved is generally more favorable with a trust if somebody's trying to get things done. A huge benefit of a trust is, unlike probate, where the accounts are frozen until somebody is actually appointed as a personal representative and approved by the court, things are frozen in probate. With a trust, nobody has to approve the trustee, because if you have already designated someone as your successor trustee, that's who it is. Nobody can, ask the court to dispute that, because that's just what the document says, right? I mean, people of course can sue for any reason, but the court doesn't have that jurisdiction over that. That's you setting up your own backup in that sense. So it's much more immediate access to funds to pay bills and pay for the necessities initially than probate with a trust. Trust is a lot quicker in that sense. In terms of cost, it tends to be cheaper to administer a trust overall. And again, partially that's because of attorney's fees. It's easier to do trust administration. There's less time involved with the attorney in trust settlement, again, on an average basis than there would be in probate. So whereas probate could be anywhere from 3 to 5% of someone's estate, with trust settlement, you're looking closer to that, maybe 1% or maybe a little under 1%, depending on, the complexity of the situation. So, in a $1 million estate situation, that's a difference of, $20,000 at least. And that can make a big difference for the people you're leaving money to. So time and cost tend to be more favorable. Another thing with trusts is that they're not public record. So unlike that probate situation where someone could, look at the will or request a copy of the will and see what's going on and, how much money there was in the estate and all of those sorts of things, trusts are not available for public record. Nobody has a right to that information other than the beneficiaries in order to determine that they're getting their fair share, right? So if I'm a 25% beneficiary of a trust, that beneficiary, or me as that beneficiary, I'm entitled to enough information to make sure that I know I'm actually getting that 25% and that somebody's not, pulling the rug over my eyes and saying, yeah, by the way, that is 25% when it really wasn't. So, but the public is not entitled to that information. So the big difference between those two would be time, cost involved, and then privacy is a big concern. Now with trusts, you can't name guardians for minor children in trusts. I've seen people try to do that. It wouldn't do anything because the court is the one that has to approve that, right? I mean, they want to make sure that whoever they're approving as a minor guardian for a minor, making sure that they're actually fit for that role. There's a public interest in that. So you can't do that in a trust, but it doesn't mean that you don't do some combination of the two. Maybe the only reason you're using probate is for the nomination of guardians, whereas the rest of your estate is not going through probate. That's perfectly fine. So if probate avoidance is the goal, you want to use a trust over only relying on beneficiary designations. And the big reason for that is beneficiary designations just do not account for unforeseen circumstances. They're not meant to. They're basically a contractual obligation that the company has after you pass away. But they just leave the assets to the people listed in the way that it's listed. And by that, I mean by like the percentage that it's listed. So what you can't do is if that beneficiary, for example, is suddenly in a nursing home or they're subject to creditor claims or getting sued for any reason, well, they may not be able to have that money protected for them because it's just being left to them. You can do protection planning in both a will and a trust that if any beneficiary is in those situations, the money they receive from you is protected and not available for those liabilities. So you can do that in both a will and a trust. You just have to make sure that the assets you're leaving to those individuals are actually subject to the provisions within those documents. So with a will, in order to make the assets subject to the will's provisions, you actually have to have those assets funnel through probate or at least be left in a way that works with the will. If you are using a trust, for example, the difference between that and how you would have assets subject to a will is the trust either has to own those assets during your lifetime, or at least the trust has to be the beneficiary of those assets after you pass away, because that is how a trust controls assets. A trust without anything, a trust that doesn't own anything rather, is just like a will that has nothing going through probate. It doesn't do anything for you. And it's almost worse in the sense of a trust not owning anything when you pass away, because trusts tend to be a little more expensive to set up on the front end. So you want to actually use it, right? Sometimes what I've seen happen with trusts as well is the attorney drafting the trust would have created a will for that person as well that says, in the event I pass away and something is subject to probate, my will points everything back to my trust. It's what we call a pour over will. I think of it sort of like you're taking a pitcher and you're pouring everything back over into the trust. The whole problem with that, though, is that shouldn't be your first goal with your estate if you have a trust. The main goal of a trust versus a will would be to avoid probate, especially for after someone passes away, right? For that's a goal of the trust. So why would you force it through probate just to put it back in the trust? So you want to work with somebody who will help you align your assets properly with whatever document you're using. You don't want to be stuck in a situation where you get the advice on the documents and then you don't know what you're doing with the assets or how to title things or move things around, right? You want to get advice on that if you're going to set that up. And then just another reminder here, any questions that somebody has, if you want to submit those, I know we're running close on time here, so I'm happy to answer anything that comes in. And then just one last reminder too on the things you'll be receiving from us, the handout that I was pointing out earlier, as well as the place for you to reach out to us to set up an initial consultation if that's something that you'd like to do. They are complimentary again. So if you have these concerns about probate or trust settlement or just setting these things up for yourself, it's a good use of time to come in and talk to us. And then oh, and actually, you'll also be receiving one of our books on probate and trust settlement as well if you registered for this. So and make sure that you have your mailing address as part of your registered or participation, I guess, sign up. And then you'll also get a book on a lot. It's a good summary of what I'm talking about today. Okay, so with the big thing again, I'll kind of leave you with anyway, if I don't see any other questions come in, would be the big reason that you want to make sure that you are actually, whether it's a will going through probate or a trust, that avoids probate, the biggest thing you want to make sure you're doing is making sure that those assets actually use the tools that you've set up. It doesn't do you any good or your estate any good, and it just creates more issues than you'd want, than anyone would want to deal with, by having these documents and then not actually ending up having any use for them after you pass away. It happens a lot, especially with wills, not because there's anything inherently worse about a will than a trust in terms of administration. It's just mostly that people have wills and then have none of their assets go through probate, or maybe some assets going through probate and others not going through probate. So it just creates issues for people. So making sure that your assets actually use the tools you have in place, that's the most important thing, whether you're using a will or a trust. Whether you use a will or a trust is going to depend a lot on your actual goals of what you want to happen. I should say, I haven't mentioned this yet, but there's really no amount of money that somebody needs to have in order to set up a trust, right? It's not, I think a big misconception about trust is, oh, they're only for people with millions and millions of dollars, right? There are certainly types of trust that somebody would maybe use if they have like Bill Gates level money, over somebody who is maybe more middle class, upper middle class, somewhere in that neighborhood. They're going to have different trusts that they would use. But whether or not you use a revocable trust or a will, for example, is not going to be based off of how much money you have. It's primarily going to be based off of whether or not you're trying to avoid probate. That's probably the key difference for whether or not somebody would go with either of those. I'm getting some reminders here, but one thing with that book, you'll have to respond to the email you'll receive with your mailing address if you want to get the book, just an FYI for you guys. Okay, so I'm running short on time here and I don't see any questions, but just one last reminder, if you do want to come in and talk to us, please fill out that initial consultation request form that you'll receive. And we'll set aside about 2 hours to talk to you guys. And again, it is complimentary. And then just a reminder that if you're interested, our topic next week is on gifting in terms of gift taxes and long-term care and how gifting plays into long-term care, what sorts of issues it can create as well. So if you're interested in that topic, please sign up for that. Otherwise, I'm still not seeing any questions. So I will sign off for today and look forward to seeing you guys next week.